So for the Hansard record, could you each please state your full name and the capacity in which you appear today?
Malcolm Stewart, I'm the Vice President of the Rule of Law Institute of Australia.
Nick Clark, the Education Coordinator of the Rule of Law Institute.
Thanks very much. Now, I don't believe that we've received a written submission, so would you like to make a brief opening statement and then we'll take your questions?
It might not be that brief because there is something important that I want to say about this. I do apologise for not having a written submission. We were invited a couple of weeks ago.
Okay.
If there's anything that arises out of what I said that is of interest to the committee, I'm more than happy to proceed in the next couple of weeks to put anything you require in writing. So thank you very much for the invitation for us to attend. I've read most of the submissions and it's clear to me that this is a very difficult area of public policy. It's a massive task and congratulations to this committee for taking it on. I'm endeavouring in these submissions to try and make your task easier, and ultimately I only really want to focus on one overall area which I think to a large extent has been overlooked by these submissions. Before I do that, I just wanted to mention a little bit about the Institute. I know some of you senators know about it. We're non-political, we're not for profit, and we receive no government training. We employ 3 staff, 2 high school teachers, including Nick and the CEO. The teachers that we employ teach rule of law in secondary schools in Australia. In particular, we're active in Victoria, New South Wales and Queensland, including in regional activities. We're also active in a number of university law schools and journalism schools, and the Institute currently sponsors a professorial rule of law chair at Sydney University Law School, which is currently occupied by Professor Lindgren, who's a retired federal court judge. As I've mentioned in different contexts, Australia is a respected rule of law country, and we want it to remain that way. But whether or not it does primarily falls onto this Parliament to ensure that this country's laws are simple to understand and not infected by what I might describe as arbitrary discretions. The notion that an absolute ruler had the power to pry into any aspect of the lives of any of the ruler's subjects was emphatically rejected in the English Bill of Rights in 1689. This document remains the cornerstone of the rule of law throughout the democratic world. It inspired in part the Bill of Rights and the Fourth Amendment 100 years later in the United States, which gave the right of the people to be secure in their homes and houses against unreasonable searches and seizures, except by warrant on probable cause. The serious problem this Parliament has with the telecommunications intercept laws, as I see it, is there is either little or no public confidence in this system. It is not just me saying that, but a number of respected commentators, both in this area and professors in universities, have said it, including during the last 4 months. There are several reasons for this, if I might address them. Firstly, recordings of Australian telephone calls, emails, SMS, internet records, metadata, voicemails, etc., can potentially be accessed without the person who's the subject of access ever finding out that this has occurred. This is very, very different to what I might describe as a normal search warrant of premises where the occupier is present. The occupier can, if he or she thinks his rights have been violated by the search warrant, bring proceedings to invalidate the warrant. Not so in the case of accessing telecommunications data. That in itself is sufficient, in my view, for Parliament to recognise the important need for public confidence in a system that invades their privacy without their knowing and where there can be no right of redress. However, layered on top of this issue are the many revelations of Eric Snowden we've heard recently, and in particular terms we've come to know, such as PRISM and Tempora, together with the realisation that at least potentially many aspects of the lives of Australians are available to be accessed in one way or another. Metadata by itself can be a rich source of information about a person's life and their associates. In making the above comments, I'm not suggesting that public confidence be restored by removing any of the various types of interception warrants, stored communication warrants, or access to existing or prospective telecommunications data. But if you're of the view that public confidence has been eroded and you need to restore it, then, in my view, there is a relatively simple solution. When I look at the Act, the thing that concerns me the most is the power and the way it is given to the issuing authority that authorises access to the telecommunications data generally, and by that I include intercepts. Can I outline some of the problems as I see it? Firstly, it is not clear from the Telecommunications Interception and Access Annual Report that any telecommunication intercept warrants and these are the most intrusive type of warrants, ever get refused because the statistics we have linked together in the one category, refused applications with withdrawn. So there's a possibility that none of these type of very intrusive interception warrants were refused in the 2013 financial year. But even putting that problem to one side for a moment, we do know from the statistics when we add up the refusals with the withdrawal applications that less than 1% of applications for service warrants, 1%, less than 1% of applications for named person warrants, and less than 1% of applications for B-party warrants were refused. In the case of warrants authorising the entry onto premises, none were refused. There are three reasons, I think, for the very low level of refusals. And the difficulty here, and the reason why public confidence is being eroded, is a very simple one, and that is this process is seen as just a rubber stamp. The obvious one for the low level of refusals, and you've probably heard this before, is that the issuing authority only hears from the agency applying for the warrant. It's an entirely one-sided process. If a warrant is issued when it should not have been, in most cases the person who had their private and confidential communications accessed will never know that this has occurred. This significant imbalance can be rectified by increasing the power given to the issuing authority to rigorously consider and, if appropriate, reject the applications. Unfortunately, this part of the Act, and I'm referring now to Chapter 2 and Section 46, and I'll just go to an example, is not about refusing applications or rejecting applications. It's all about granting them. The usual type of wording you see in search warrants, and indeed in some parts of the Act, but they're in the minority, is that, and I'll take you to 46, subparagraph 3 if I might, says a judge or nominated AAT member must not issue a warrant in a case to which subparagraph 1D2 applies, which is the B party warrant, unless he or she is satisfied of the following. Must not issue a warrant unless you're satisfied of the following. That is the standard type of wording we see in search warrants. However, if you go to 46, which deals with service warrants, you will not see those words. And it isn't just a matter of words. All right? In that, they talk about if a member is satisfied of the following things, the judge or the AAT member may, in his or her discretion, grant a warrant. It is a significant difference in wording, particularly to lawyers. If you want to have rigorous consideration of these applications, these provisions need to be altered to give the relevant issuing authority the power to say, no, I'm not going to issue this because it doesn't meet one or more of these criteria. Can I also talk in this context too about the restrictions and conditions that are placed on search warrants? Surprisingly, there is no express power in Chapter 2 that permits the issuing authority to impose conditions or restrictions when an interception warrant is granted. Rather, there appears in a section that talks about the form of the warrant, which is 49.2, it simply says a warrant may specify conditions or restrictions relating to interceptions under the warrant. That is a very backhanded approach to what I think should be an express power given to the issuing authority to impose whatever conditions they think appropriate. And I think that list should also come with possible examples. And we see in the case when we look at the type of conditions which are reported in this annual report, the conditions where they're imposed. For an interception warrant, 2.6% of those contain restrictions or conditions. A named person warrant, it's down to 1.4%, had conditions attached. B-party warrant, I'm pleased to say, increases to 5%, had conditions attached. So in my respectful view, these provisions need to be reworked to make this a more rigorous process. The next thing I wanted to come to is who is exactly the issuing authority. And at present, if we're talking about interception warrants, both AAT members and various judges have been granted authority to issue interception warrants. In my view, consideration should be given to ensuring that the more intrusive the warrant, the more senior should be the judicial officer or AAT member that determines the warrant's application. And I can see no practical reason why in the case of an interception warrant, their issue should only be considered by a federal court judge. Can I now move on to stored communications? But I really want to make the same point in stored communications. Stored communications, they're relatively few. There are 563 issued last year. However, in saying that, I've got to also say that more and more individuals and companies are now storing their confidential and private data in the cloud. Such warrants also seek access to communications, including the form of SMSs, emails and attachments to emails. For these reasons, consideration should also be given to having these applications for warrants rigorously determined by a federal court judge. As stored communication warrants also include communications, the same rigorous consideration of the application I suggested with telecommunication warrants should be considered. This will hopefully ensure proper scrutiny of these types of applications. Dealing with the third category, telecommunications authorisations. These authorisations, I'm happy to say, are important to law enforcement agency investigations. There's a significant distinction, legally and practically, between the content of a communication and the details of the communication in terms of its metadata. Nevertheless, that said, a lot of personal and confidential information can be inferred from metadata, and there are examples that abound, and being involved in criminal matters as I have, where two defendants might be accused of something, to see an increase in communication between them without knowing what that communication is at the time of an alleged offence can be of obvious interest to law enforcement agencies. But that also said, that type of material in innocent cases you can also tell a lot about what the person might have done and various associates that they have. My suggestion is this process under Chapter 4 of the Act also be reviewed to make it more rigorous, not with a view to reducing the number of applications, but only to ensure proper scrutiny of these applications. There were close to some 320,000 applications last year, and there's no suggestion and there's no record in the annual report that any of those were refused or that any conditions were imposed. And I deal now with, I think, the final two matters I want to, and I'll be quite brief. What happens when something goes wrong? And it does. If a warrant was issued that should not have been, and we know with warrants in other situations some things do go wrong, and I'm referring there to, in particular, the recent matter looked at by this court where the AFP obtained a warrant to search the premises of Channel 7. A very different circumstance to here. But nevertheless, things do go wrong. The oversight by Parliament and the Ombudsman are important, but I would add not as important as ensuring that the issuing authority is armed with the necessary legislative tools. But in addition to that, however, if a person, the subject of a warrant or authorisation, does find out that information about his activities or communications by him have been accessed, and that might be in circumstances where he is a defendant in criminal proceedings, that person should be given the express right under the Act to challenge the issue of the authorisation or the warrant. We know from recent experience it happens that an issuing authority can be misled into granting an application for a warrant. I'm not suggesting this is done deliberately, but would be quite wrong to think that that does not occur or that it is unlikely. In 2002, the United States Foreign Intelligence Surveillance Court released an opinion stating that in over 75 applications for warrants and wiretaps, the court had been misled by the FBI and Department of Justice, no less, on those 75 occasions. It's important that when it is shown that a warrant or authorisation should not have been issued, that evidence obtained by that warrant or authorisation should not be allowed to be admitted into evidence in any civil or criminal proceedings. In my submission, if these changes I've suggested are adopted in one form or another, various issuing authorities will no longer be seen as little or nothing more than rubber stamps. Applications for warrants and authorisations will be a much more rigorous process. That in turn should help restore public confidence in this system, and that should be a benefit to all players, including law enforcement and other agencies that rely on warrants and authorisations to help keep the same public safe from serious criminal and other activities. Thank you. Senator, those are my submissions.
Thank you very much for that. I'm glad that we now have that all on the record. Senator Sassoon? No? Senator Marshall? No, not at this stage. Okay, I will. I might start with, you were speaking actually relatively quickly, so I might have missed something important. No, that's fine. You made a distinction between the seniority of the issuing authority as opposed to the gravity of the intrusion. Were you proposing that at some point the AAT be cut or not allowed to be an issuing authority?
Yes, there may be The simple answer to that is yes, certainly yes with respect to the interception warrants. I mean, they're serious, the intrusion. I think that those should be limited to federal court judges. With the stored communications warrant, the difficulty is there. It's perhaps that's a lower case. So I still think you can access emails, SMSs, attachments to PDFs, which may be letters and things like that too. So I think, I want to give more thought to that, but my inclination to that is to say yes for those type of matters, because I regard them as serious intrusions into communications between people that are private and confidential.
So that's going to leave, so kind of graduated hierarchy of issuing authorities. I want to draw out a little bit more your views on telecommunications data, the 320,000 odd that you mentioned on the way through there. The degree to which there's a view, not often heard in this parliament, but there's a view out there that the distinction we make between content and metadata is increasingly arbitrary, that if you have enough envelopes to stack up, you effectively have content. You can have somebody's life in a map. Do you have any views about the degree of, you've pointed out some important flaws or improvements that we could make to the warranted surveillance process. What do you think we should do with a warrantless process that is increasingly
That is a very difficult question. I do appreciate what you said, and I think I touched on that briefly about you've effectively got content. I have some examples, but I won't use them. It's not particularly pleasant ones, but it's easy. If a person has made 3 calls or 3 or 4 calls within a short space of time, you know who they're to, you can very quickly work out what the person's thinking and the content, and you can take a pretty good inference as to what that content can be if there's a logical progression between them. So I hear what you're saying about the difference not much difference between the metadata and the content. Nevertheless, that is a distinction that has been part of our legal system for a long time in terms of communications, and I think I'm using it in a way to say that with those communications it should have much greater scrutiny. I don't doubt that in certain cases in metadata, and perhaps it's wise to say all cases to make sure nothing slips through, that you will get close to content in certain things, and that's what law enforcement agencies are looking for. They're looking for the pattern, and it's not just. I look at, again, some of these warrant provisions. One of the issues I've got, will getting a warrant be likely to assist in your investigation? Will always be likely to assist, because you're either going to rule someone out or in. It's a very weak test. But with the metadata, I don't have first-hand experience at that, but I can see it becoming an increasing problem. But I think the way I would try and deal with it, because I know how useful this material is to law enforcement agencies, is again the rigorous process you need, and to ensure that you're only getting the bare minimum of material from the metadata, and that it's being properly used and confined. That's how I would try and say it. As the issuing authority is there at the coalface, he's got to make the determination from the law enforcement agency, wherever the agency is, what information I want to get.
There's no issuing authority. The issuing authority is the agency itself.
There's a person there that makes a determination.
Hundreds and hundreds and hundreds of people.
Thousands.
I guess the reason I'm dwelling here is that the distinction that you draw, that was probably clear cut in 1979 when this Act was drafted, was that metadata was, the billing records. Where does this person live, at what time, and for what duration was the call? There are vast new categories of metadata that didn't even exist when the Act was drafted. That distinction to me has become increasingly porous. If you add that social network mapping that you were describing before with the quite detailed locational data in real time, how is that any less invasive than reading somebody's email?
I think that's a very fair comment, Senator.
So, go ahead, Senator.
Just, I sense your outrage and annoyance.
I'm not outraged and annoyed, but, to me, it's obvious we have an independent judiciary. They're the ones at the coalface.
But explain to me where the harm is, because I'm...
Harm in what?
Well, where's the harm that you're outraged about?
The harm that I'm outraged about is that the public have lost confidence in this system.
Did they ever have... maybe this is just a personal point of view, but when someone was explaining the internet to me in the mid-90s, it was sort of explained that you would never use the internet as a form of secure communication because nearly anyone can listen to it. And the same with mobile phones, really. I remember again in the early 90s, a friend of mine had a machine where he could just randomly listen to people's phone calls and thought it was a great lark. So do people really have this view that, the email communications and mobile phones are so personal and so secure that they ought to be so outraged when they find out that people can listen in on it?
I think there are two situations, and I think you're partly right. I think a lot of the email communications that I see, you look at them and you think that person could not have written this with a view to anyone else reading it. And, because it's in bad taste, it says something, let's leave it at bad taste. And that happens a lot, I've got to tell you. I see emails left, right and centre when you just know people, they start talking about drugs or things like that in a casual way. But then if you say to them privately over in the corner, do you understand and know this, as opposed to them sitting in front of a computer when they're busy and just typing something and letting it fly, I think they would recognise that. So I think there's a little bit of a dichotomy there in what you're saying. I hope that answers your question.
Well, again, it's... Look, I'm interested in the privacy issue and don't take the question as meaning I'm not actually
this needs to be tested.
Concerns about this. But I'm still not quite sure. Like, it's the issue of sharing information that might have been obtained by warrant by one agency but identifies other criminal activity which other agencies might be interested in. What's the harm in sharing that? Why does the privacy of someone that is allegedly or possibly in reality committing a criminal act, why should they get the protection? And again, the point that you made...
I'm going to agree with you, Senator.
The warrant was, maybe not at the time properly constituted. Why should that evidence, if it's still created evidence or provided evidence of a criminal activity, why should the court not be able to take that into consideration?
Well, if it does give evidence of criminal activity, then I think the ability to challenge it is going to be very, very difficult. But if there is... I'm about restoring confidence in the system. I'm not suggesting for 1 minute that we don't have these warrants and if information is obtained it shouldn't be shared. What I want to make sure is that rigorous process has gone through. So the very people that the law agencies and everyone else wishes to protect, and quite rightly so, can feel safe and secure in the system and that it's working properly. And that I think in those circumstances people are prepared to lose a bit of privacy. You live in a democracy, you're prepared to do that. But it's got to be, I think it's got to be rigorously enforced as to what you want to do. I'm not suggesting that we stop any of these types of warrants going ahead. And the law enforcement agencies in this country, I think, do an excellent job by and large. But there will be times when there are slip-ups. And I think the more rigorous process you've got leads to people having confidence in it. And I think that's just a better system. It just works better. It works better for Parliament, and it works better for all of us if you have public confidence in it.
Oh, thank you.
I've been using the TIA Act annual reports for the last couple of years and find them actually an excellent reference, but you made a couple of critiques, I think, on your way through. Do you have any significant proposals for improvement on public reporting of what goes on?
I mean, there are a lot of things you could ask for here. I don't know how practical it is to get. I'd certainly like to see the difference between refusals and withdrawals put in here, because I think the easy answer and the reason why there is a lack of public confidence is because people just see this as a rubber stamp. And so I think that would be a good indicator in here. I'm not sure about the statistics. They don't quite work for me as to, again, to create public confidence. If you started with the proposition, well, there are all the warrants we've got, there's the evidence we've obtained from it, and we were able to use that evidence in these proceedings. I think it's there to a large degree, but I couldn't get the numbers to add up. There was something wrong in trying to work out. Then you get a sense too of how many times when you issue these warrants, the information you get is actually being used in court proceedings. I think that would be a very useful indicator as well. But also bearing in mind, of course, what I said, that part of all of this is ruling out people, and that's a legitimate investigative tool to get this material to rule people out.
Do you have a view on that this reporting in the TI Act annual report is partial because ASIO is not obliged to report against the Act? So we don't know, for example, to within any orders of magnitude, how many telecommunications data requests they make, how many warrants they make. Do you think they should be reporting against the same criteria as the federal police that also conducts very serious investigation?
That's a very difficult question regarding, obviously, national security from ASIO's point of view. I think, I don't know whether there's some general information they can give. There may be valid security reasons why they should not have to give information in the same form as the AFP. But I think there's probably some generalised information they can give as well in terms of numbers and that type of thing. I don't think that gives anything away. You may not want to go into details of the type of offences and that type of thing, but it would be interested to know general numbers and that information as well. But that, obviously, before making any call on that, that's something you need to discuss with ASIO too to see what problems that creates.
I have done. I've actually lost count of how many times I've had that discussion with them.
Okay, I see.
I was just after an independent view.
Yeah.
And the other thing that you did mention in passing on your way through was, I think in the context of confidence in the system, was the revelations of very large-scale indiscriminate surveillance in the United States.
Yes.
What's your view on, like, are we completely wasting our time tightening up our procedures and our processes and our accountability here if everything's just being dumped off into some massive server farm in Utah? What's the degree, do you think, that there's even worth in these accountability mechanisms occurring here in Australia, given the scale of what's occurring overseas?
Can I say this, that, and this is my own personal view, but I do not regard the United States as a very good rule of law country. Australia is streets ahead, and I want to try and keep it that way. And I think some of the reasons you've just touched on, and I think one of them might be Verizon, when data from 120 million customers of Verizon was just grabbed under an order issued by this secret court, the one that I referred to earlier, the foreign, whatever it's called. And it's also the one that I referred to where they issued the judicial opinion saying that in 75 cases the court had been misled in the grant of those warrants. So there's a lot of information in the US and to indicate that its rule of law is not anywhere near as strong as ours. And I think we should continue to ensure that we remain a rigorous rule of law country. That's what I'm about. In terms of, is it weakened by communications between or Americans be able to get our data from one way or another, either through here domestically or where there's been communications between us and the United States or another country? Yes, that concerns me, but I wouldn't want to say you just throw your hands up in horror and just let it all go. I don't think that's the solution. I think we should just keep the rigorous applications of all of this. Yeah.
So one example, I'm certainly not the one throwing my hands up in despair.
No.
I plenty that we can do. But so one example I'll give you, that the operators of the submarine cables that make landing on Australia's an island continent,
yes,
all have signed agreements with security agencies.
Yes.
That it looks as though that material's all just being spliced.
I understand that.
So that's one example I guess I'm pointing to. While we go into exquisite detail here about the hoops that law enforcement agencies need to jump through, while this stuff's getting vacuumed off and stored somewhere else, do you have any visibility or any views on the applicability of Australian law to those sort of arrangements, for example, governing those cables?
That's actually a very good question. I mean, as I understand it, the various companies who want to put the submarine optic fibre cables into the United States will simply not get a contract unless they permit access to these things, which is obviously a serious intrusion. But I think it is too hard that once the communication gets to America, you either take the view that you've got to stop the communication, which you just can't do in this day and age, or you've just got to accept whatever's going to happen in America happens there. But we're not going to follow the same downward path into that. I think
all of the fibre lines that arrive in Australia have these agreements signed on them as well.
But not for Australia too. I assume you're referring to sort of Project Tempora or whatever it's called. That's
whatever the local equivalent is. So there was an agreement that I think was kind of hidden in plain sight, wasn't secret, that Telstra signed
with
Australian
Australian,
intelligence
was it?
agencies.
Okay. I wasn't aware of that.
Yeah.
I wasn't aware of that.
All right. We can leave it there. And we have